This is Michael Popok, Legal AF, because Donald Trump is lying to the American people and telling them that during the execution of the search warrant at Mar-a-Lago 2 years ago in August, that the FBI, the Department of Justice, intended to assassinate him, to execute him during the execution of the search warrant. Jack Smith, the special counsel, had no choice but to file what effectively is an emergency application with Judge Cannon to get her immediately to exercise her inherent authority to make sure that the administration of justice is not interfered with and lives of law enforcement are not put in jeopardy by amending the conditions of Donald Trump's release, because remember, he is a criminal defendant who's been released with conditions, and make sure that as part of the conditions they be modified so that Donald Trump is not permitted to attack and smear law enforcement and claim to his followers who have an itchy trigger finger, to paraphrase Donald Trump, as we saw in Jan 6, that they don't do grievous bodily harm to law enforcement interfering with the administration of justice. This just in, the government's motion for modification on conditions of release. Now, she doesn't do this, and I'm going to read to you from the pertinent parts of this motion that was just filed now. Judge Cannon doesn't hold a hearing and or grant the modification after briefing, and Donald Trump continues to do what he's doing. Rest assured, Jack Smith has his ticket to the 11th Circuit Court of Appeals for an appeal and maybe to argue for the removal or reassignment of Judge Cannon. It's that important. It's that serious. Because you have Donald Trump running around on social media saying the following. And I'll just tell you what that is first, and then I'll tell you where we are with the filing. This is what Donald Trump is telling his followers and anybody else that'll listen. Crooked Joe Biden's Department of Justice and their illegal and unconstitutional raid of Mar-a-Lago authorized the FBI to use deadly lethal force. Trump also sent an email stating that the government was authorized to shoot me, was just itching to do the unthinkable, was locked and loaded, ready to take me out and put my family in danger. And shockingly, Trump continued to claim, the Department of Justice authorized the use of deadly force in their illegal, unconstitutional, and un-American raid on Mar-a-Lago that would include against our great Secret Service, who they thought might be in the line of fire. Predictably, as he intended, they were. He claims that they were there to assassinate Donald Trump. That is a lie. And it's not something that Donald Trump just learned. It's not true. And I want to walk through the motion. First, reminded her of her obligations and duties that the court has, on page 2, quoting, an independent obligation to protect the integrity of this judicial proceeding and should take steps to immediately halt the dangerous campaign to smear law enforcement and that they're in imminent danger. They also reminded the judge on page 2 that the entire search warrant execution, that's the only execution that matters, was done under the auspices of a federal magistrate in Fort Lauderdale, Judge Reinhart, who ultimately reports to Judge Cannon. He heard all the evidence. He issued the search warrant. It was coordinated because Donald Trump does have Secret Service. It was coordinated with the Secret Service. It was done and executed in August while Donald Trump was known not to be there on purpose. It was coordinated with his attorneys, with the Secret Service, with Mar-a-Lago staff in a way you never do with a search warrant. Search warrant should just be knock and announce, knock down the door and execute the search warrant. You don't give the party that you're going to execute against time to delete the servers, the files, the computers, the documents, destroy things, spoliate things. You don't give them that time. But they had to here because it's Donald Trump with a Secret Service detail. So they scheduled it at a time when they knew from talking to the lawyers like Evan Corcoran for Donald Trump that Donald Trump's family and he were away. Donald Trump decamps to Bedminster once the mercury hits 80 degrees. And so August at Mar-a-Lago, for those that don't know West Palm Beach or Palm Beach, where I lived at one time, is hotter than Hades in August. He's in Jersey, and that was on purpose. Also, there is a use of force policy that's included in every search warrant in America. It's a boilerplate. It's a template. And it tells the executing officers who are FBI, who have to, by law, carry their guns. It tells them when and prevents them and limits their use of deadly force. It doesn't authorize deadly force to take out Donald Trump and his family, as he claimed, who weren't even there, and we all knew they weren't there, but tells law enforcement the limited circumstances when they can use it, which is if they're an imminent threat of death or violence to them, which of course never happened. No shots were fired during the execution of the search warrant at Mar-a-Lago. There was video, there was photography, there was interviews, there were video cameras, but there was no assault on Mar-a-Lago. And Donald Trump knows that, and of course, he's lying to them. Were they locked and loaded? Sure, FBI agents carry weapons. The special counsel outlines all of that for Judge Cannon. The way we got here is that originally back in February, Trump filed a motion to suppress evidence obtained through the search of Mar-a-Lago and had a lot of these papers attached, but they were redacted. That's February 22nd, 2024. May 21, 2024, he files because Cannon made him do it, files a redacted version of the suppression motion and the exhibits on the public docket. Then he uses that to point to them, Trump, and say, aha, look at the use of force policy. He doesn't frame it as a policy. Directive. They were authorized to shoot me. They were itching to do it, right? They were going to use deadly force. They were going to take out my family. They were locked and loaded. It's just the boilerplate about the limitations on the use of deadly force in the execution of any search warrant anywhere under federal policy. And you weren't there. You know you weren't there. It was coordinated with Evan Corcoran, Christina Bobb, and Jennifer Little, your lawyers. It was coordinated with Tim Parlatore. It was coordinated with Secret Service, with the staff of Mar-a-Lago, in a way that no other target of a search warrant would ever be. But Donald Trump likes to lie. What's the word? I don't know why I struggled with that. Donald Trump likes to lie to the American people. Right? And since it was a slow news week going into the Memorial Day weekend, let's claim that the Department of Justice and Joe Biden was going to shoot through my Secret Service detail to take me out during the execution of a search warrant that I wasn't even there for, and my family and I were in Bedminster. I don't know where Melania was, but at least he was there. And this isn't just laughable and a lie. It's dangerous, and it puts law enforcement at imminent threat of danger, because now all of Donald Trump's followers, and he knows they follow him, in a call and response method, see Jan 6th, every time he calls for violence, he gets violence. He pushes that button and they do it, right? He pushes that button and the torpedoes are fired. And so they're worried about Donald Trump claiming that, and some crazy, right, or non-crazy, who's fallen down the rabbit hole of social media, who gets activated like a sleeper cell for Donald Trump, tries to take out law enforcement. And I mean really take them out. And that's where the motion comes down to. What they say on page 7 is Trump has grossly distorted these standard practices by mischaracterizing them as a plan to kill him, his family, and Secret Service agents. That those deceptive and inflammatory assertions irresponsibly put a target on the backs of the FBI agents involved in this case, as Trump well knows. As the D.C. court in 2023, in their ruling about gag orders related to Judge Chutkan's case, ruled Trump himself recognizes the power of his words and their effect on his audience, agreeing that his supporters listen to him like nowhere else, and that he has a documented pattern of speech, and it's demonstrated real-time, real-world consequences pose a significant, imminent, and foreseeable threat to witnesses. Now, the lawyers for Donald Trump in this case, which I think is there, is John Lauro and Chris Keiss, they didn't see it that way. They didn't even want to do a meet and confer mandatory conference with the government before they filed this. They said, we'll get back to you on Tuesday or a week from Monday. We're busy. It's a long weekend. We don't have time. We don't want to get on the phone with you. In the meantime, as noted in the actual filing in footnote 1, Donald Trump was out there doing the exact same thing again, smearing and endangering the agents who executed the search warrant, right? Where he said in his Truth Social, just on the day that his lawyers were saying they didn't have time for this meeting and it wasn't really important, he's saying in his retruthing He claims that the FBI was authorized to use lethal force on Trump or anyone at Mar-a-Lago, M-A-L, while the FBI DOJ plants evidence to frame Trump. I love when he talks about himself in the third person. What was the evidence that was planted? How would he even know? Donald Trump didn't keep an inventory of all the things he stole from the American people and the National Archives, right? Those 73 boxes, he has no idea what's inside of them. So how does he know anything was planted? And there's photographs of all the boxes, including the ones that were falling apart, documents falling out, and the ones that were being moved surreptitiously by Walt Nauta and Carlos D. Vieira and everybody else. So again, lie upon lie upon lie. What they're asking for under the Bail Reform Act is that this judicial officer, Judge Cannon, modify the conditions of release, in particular, that they not commit any federal, state, or local crimes. And of course, these are threats against federal law enforcement, which are also crimes. And so what they're asking for on page 9 in particular is that Judge Cannon should exercise her authority to impose a condition that Trump may not make public statements that pose a significant, imminent, and foreseeable danger to the law enforcement agents participating in the investigation and prosecution of this case, at the very least. The fact you have to even write that. Whether a particular statement meets that test must be determined in the full context. And they also said this is not a First Amendment issue. Like any other criminal defendant, they say on the bottom of page 9, the government, Mr. Trump has a constitutional right to speak, right? And his millions of supporters have the right to hear him. However, his right is not unlimited. The restriction that a defendant avoid all contact with a potential witness who may be testifying, for instance, is so commonplace that Mr. Trump does not dispute the court's authority to have ordered him, as a condition of pretrial release, not to communicate with witnesses. And so you have to take steps to regulate to make sure that there's no outside interference on this system, right? And what they say on page 10 is Trump cannot evade this legitimate limitation by dressing up his inflammatory messages, such as these, in political speech garb. He can't say First Amendment speech can't get me. I think the FBI was going to assassinate me. You may not. My opinion. And my opinion matters. So as they end it this way. Signed by Jay Bratt, counselor for the Special Counsel, and David Harbach for the government. The law enforcement agents, this is on page 10 over to 11. The law enforcement agents participating in this case conducted the search in an appropriate and professional manner, subject to the Department of Justice's standard use of force policy. Trump's repeated mischaracterization of these facts in widely distributed messages as an attempt to kill him, his family, and Secret Service agents has endangered law enforcement officers involved in the investigation and prosecution and threatened the integrity of these proceedings. A restriction prohibiting future similar statements does not restrict legitimate speech. Trump's conditions of release should therefore be modified to prohibit similar communications going forward. This landed on the desk of Judge Cannon now. She either sets a briefing schedule for this in expedited fashion, or you're going to see another emergency motion filed attaching all the other ways that Donald Trump is making these same false, salacious, defamatory statements. And then they'll get a ruling one way or the other. It'll probably be a month from now. And then Jack Smith hopefully can get to the 11th Circuit if she rejects this motion. You'll follow it hopefully right here on Legal AF and on the MeidasTouch Network. We do a show called Legal AF. Join us Wednesdays and Saturdays, 8 p.m. Eastern Time, and you'll find out why we call it that. You can kind of figure it out now. We curate the top 4 or 5 stories at the intersection of law and politics. We bring it to you right here. Wednesdays, I do it with Karen Friedman Ignifilo. Saturday with Ben Mysalis, my co-founder. And then I do hot takes like this, I don't know, about every hour right here on the MeidasTouch Network. The network you're building with your bare hands. No outside investors. We're completely independent. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Enough! Send it to the big house, not the White House. Get the new exclusive tees, mugs, and stickers right now at store.meidastouch.com. That's store.meidastouch.com.